Hi everybody, this is Professor Jameson again. This lecture is going to be on how to draft an answer. Okay, the good news is drafting an answer is a lot easier than drafting a complaint. Okay, because you don't have to have legal theories and things like that. Now I've provided you with an example of an answer to complaint. It should be listed down there. I recommend that you print that out and follow along. Okay, this is an answer to a real complaint. Had to do with a contract matter. The reason I didn't delete the names of the plaintiffs and defendants and all that is because I represent one of the defendants in the lawsuit, Jayco Oil, and that's one of our family businesses. So there's no issues of privacy or anything like that. So I've just kept it up there the way I actually filed it. Okay, so as you look at the pleading, an answer is a pleading, just like a complaint is. Starts out the same way as pretty much any document we file with the court that we prepare ourselves. Name and address of the attorney at the top, who they represent, state bar number, contact information. Down in the birdcage, name of the court. Don't forget to change that because, you know, like if you're in Kern County like I am, you're always filing in Kern, and then you have to file one in Riverside like this, and you got to redo it. Okay. Names of the parties, name of the document, so the court knows what it is. This is an answer to a complaint. Then we have the body of the complaint. Now, the first thing I have to tell you about answering complaints is this. When you file an answer, there's two types. There's verified answers and non-verified answers. Okay. The difference is a verified complaint, which is one that is signed under penalty of perjury by the plaintiff in the case. If the complaint is verified, and usually it'll say so right on the pleading in the birdcage, it'll say verified complaint. If you're not sure, go to the last page of the complaint, and there should be something signed under penalty of perjury by the plaintiff that everything in there is true and correct. Don't confuse that with the attorney's signature. We're not really verifying anything in a way. So if the complaint is verified, then it's a pain in the ass. Because if a complaint is verified, which means signed under penalty of perjury by the plaintiff that the allegations are true, we have to go through and admit and deny each and every factual allegation in the complaint. So that takes a lot longer. We've got to sit down with the client. Is this true? Is this not true? Do we know? Do we not know? And I'm not going to get into how to answer a verified complaint because they're fairly rare. You'll see them in things like fraud, other types of causes of action, but it's fairly uncommon to file a verified complaint. So we're going to talk about a non-verified complaint, which is the average complaint that you would see, and how to respond to that. Okay. If we look at the body of the complaint or the answer, you'll see there's just an introductory paragraph comes down. Jayco Oil, la-di-dee, la-di-da, and alleges as follows. Okay, the second paragraph of the answer, you'll see that the paragraphs are generally not answered in or numbered in the answer, but we could number them. Some attorneys do, some don't. Always check your local rules to see if that's required. Okay, that second paragraph where it says, under the provisions of section 431.30 of the Code of Civil Procedure, la-di-dee, la-di-da, we generally deny everything. What we mean when we file a general denial, people have problems with this and really don't understand it, is we deny everything that's in the complaint. Now, are we denying that the plaintiff's name is the plaintiff's name? Well, not really in a way. All a general denial does is it puts every fact at issue and makes the plaintiff, if he goes to trial, have to prove those facts. Okay, so the general thing is just to deny everything. Now, if it turns out we know something is true and we deny it, is that a problem? No, it's not, because these are legal formalities. Now, if we're filing a verified answer under penalty of perjury that our client is going to sign, that's a different matter. But normally, general denial, you can use this exact same paragraph, although check the rules because this is about 10 years old and the Code of Civil Procedure might change. But this is the exact same answer, this paragraph. this general denial that I filed 300 times. Same one. Okay, so that's the general denial. We're not going to talk about specific denials. We'll talk about that if you're lucky enough to take civil procedure from me. Okay, so after our general denials, what do we have? We have affirmative defenses. Okay, affirmative defenses are ways to say, yeah, this might have happened, but the plaintiff shouldn't recover because of this, this, and this. Okay, there's always going to be some stock affirmative defenses in every complaint. Plaintiff has blown the statute of limitations. Plaintiff has failed to state a cause of action to be able to get him into court. Plaintiff has failed to mitigate his damages, so he shouldn't get as much if he wins. All these types of things. Okay, the one I've given you here is pretty good. It's a business litigation case, and it has some quite a few affirmative defenses in it. How many should you put in? Generally, the answer is rather safe than sorry. It's okay to throw too many affirmative defenses in there than miss one, because if we miss one and we need it later, then we got to go back and amend our complaint, go to court, ask the judge, la-di-dee, la-di-da. Usually they'll allow us to do that, but you know, it's another hour of work. Okay. Okay, so let's look at the affirmative defenses. Okay, I like to title mine first, second, third, fourth. There's no requirement that you do that, but most attorneys like me do. Okay, the first one in every answer is going to be failure to state a cause of action. Let's see, what's the second one? Somebody else is responsible, not me. That's the second one. I'm just going to explain these in layman's terms so you understand them. Number 3, plaintiff waived his right to recover. Okay. Number 4, failure to mitigate your damages. You have a duty to stop your damages if you can, if it's reasonable. Barred by the statute of limitations is number 5. Number 6, no contractual duty. I'm not going to go through the rest of these. You can just see what they are. What I want to do is go ahead and skip to the answer. Now, how many affirmative defenses are there? There's literally hundreds. And I used to have a list of them all. I don't know what happened to it. So what I did is I provided a link to a website. And that has some affirmative defenses, a list of affirmative defenses, and I think it's pretty good. Okay, let's move on past the affirmative defenses to the prayer. Okay, the prayer is going to end almost exactly the same in every answer. We pray for judgment. We ask the court for judgment. Plaintiff, take nothing. Plaintiff, you'll get nothing and like it. For costs of suit, okay, those are filing fees, deposition fees, things that we incur during the course of the litigation, and such other and further relief as the court may deem proper. Okay, what other things can we put in there? Well, if we have a written contract that provides for attorney's fees, we would put attorney's fees. That's really important. Anytime you're drafting an answer to a contract, you want to think in your prayer, are we asking for attorney's fees or not? Because if you don't ask for them, you will not get them. And there's only certain kind of cases where you can get your attorney's fees back. For example, contract actions. So, and then we have the signature block. Okay, like I said, this is an actual, real complaint that I filed. If it's got some typos, don't bitch. It's my secretary's fault for not catching them, right? Okay, that's how you draft an answer. Okay, remember, this is a general denial for an unverified complaint. If we had a verified complaint, it would be very different. Unfortunately, you're going to have to wait until civil procedure for me to teach you that. Have a great day. That's the end of the lecture.